É uma grande honra trazer a European Data Protection Board, Michal Czerniawski, para falar para vocês também como a European Data Board Protection age dentro das agências para trazer uma governança e controlar todas as agências a operar na mesma fórmula ou receita. Obrigado, Michal.
Thank you, Rafael, for your kind introduction. Thank you for the invitation, and thank you for having me. My name is Michal Czerniawski, and I'm a legal officer at the European Data Protection Board. The topic of my lecture today is data protection in Europe, and I will try to say a few words about the GDPR and the European Data Protection Board. First, before starting, I think I should congratulate Brazil on adopting its very first data protection law. In this context, I think this conference and our discussion take place in a perfect moment, and this event have a perfect timing. So I will focus today on personal data protection laws in Europe and the European body that I'm working for, the European Data Protection Board, so-called EDPB. The purpose of the EDPB is to ensure consistent application of the European data protection laws, in particular General Data Protection Regulation, so-called GDPR, and to promote cooperation among the as probably some of you know, GDPR, General Data Protection Regulation, entered into applications more than 2 years ago on 25th of May 2018, and it replaced the previous EU, which was Directive 95/46. Today, I would like to give you an overview of where the European Board stands and what is the state of play with respect to the implementation and enforcement of the GDPR. In particular, I would like to focus on the key role played by national supervisory authorities in this process, including the supervisory authorities of not only EU but European Economic Area. I think this is something you may find interesting because from what I know, the new Brazilian data protection law does not foresee an independent supervisory authorities. At least this is the law will be enforced, but at the very beginning there will be no supervisory authority. But correct me if I'm wrong. Coming back to the GDPR, building on the Data Protection Directive that has been in place since 1995, the GDPR puts so-called data subjects, so all natural person individuals at the center of data processing practices, and gives them back control over what is happening to their personal data. Companies, not only in Europe, but also those that target data subjects in the EU or monitor their behavior, including those established in the United States or those established in Brazil, must take a close look at what data they are collecting, what they use the data for, and how they keep and share it. GDPR provides a single set of rules applicable to everyone processing personal data within the EU or offering services in the European Union. This is the biggest change in comparison to the previous EU law, the Data Protection Directive, as the rules are now much more harmonized. And it brings back, at least in my opinion, it brings back an equilibrium between an individual fundamental right to protect his or her personal data and the lawful processing of data. Individuals in the European Union and in the European Economic Area in all the countries benefit from the same level of protection for their personal data. Controllers or processors of personal data established in European countries are subject to the same obligations laid down in the EU legislation. Their compliance is monitored by the independent data protection authority of each of the countries. In Europe, the free flow of personal data is a prerequisite for a competitive data economy within what is called in the European Union European Digital Single Market. By replacing different sets of national rules, the GDPR unlocks the economic benefits resulting from a free flow of data between different states, but we can succeed in creating this space of free flow of data only if common rules are implemented and applied uniformly in all the EU countries. These rules are implemented by national data protection authorities, which often have different traditions and are used to operate in different legal regimes. That's why I think it is important to underline how the GDPR fundamentally changed the way in which the European supervisory authorities work together. A new level of cooperation was introduced between the authorities of the EU in comparison with the previous data protection directive, under which supervisory authorities were working separately on cross-border cases. The GDPR created a duty for the supervisors to cooperate in order to see that cross-border cases are brought to a good end and to ensure a consistent application of the GDPR. As a result, the cooperation between different supervisory authorities is even closer than before. Now, let me say a few words about the European Data Protection Board. As you can see on the slide, the EDPB is an independent European body, and we are composed of supervisory authorities from all European Economic Area member states and the European Data Protection Supervisor. Our main task is to ensure consistent and harmonized application of the EU data protection rules. I think we are often confused with some kind of EU super regulator or with the European Data Protection Supervisor I have mentioned. We are not a supervisory authority by itself. We just overview what and we aim at coordinating the actions taken by national supervisory authorities, which are independent in conducting their tasks. Now I would like to highlight the key forms in which the cooperation among European supervisory authorities takes place. The EDPB contributes to the consistent application of the GDPR, first by promoting cooperation and the exchange of information between supervisory authorities, and by ensuring consistency of the measures taken by these supervisory authorities, but also by providing general guidance, issuing recommendations, and best practices. Also, EDPB is involved in so-called consistency mechanism and advises EU legislator, I mean here European Commission, about on data protection aspects related to new EU legislation and implementing and delegated acts. The board, the second way in which the European Data Protection Board ensures the consistent applications of the GDPR is through general guidelines, which also includes issuing recommendations and best practices. We have also adopted numerous documents such as statements and recommendations, including, for example, recently a document on COVID-19 tracking applications, where the EDPB underlines a number of key points to be respected when political parties, and COVID-19, and also respect to political parties processing personal data in the course of political campaigns. Finally, the EDPB is also a platform for the exchange of practices between national supervisory authorities and allows for consistent discussion and establishment of practices on topics such as the issuing of fines and enforcement strategies. As 2 years since the GDPR is applicable has passed, recently we made the first and how the EU data protection laws work, and in general our assessment is positive. We believe that I think everywhere EU data protection laws, so also general data protection regulation, should be considered a long-term project, and so we are developing a solid data protection culture throughout Europe that is built on the GDPR and the trust of individuals. I think this is something that will be happening now also in Brazil. So there is of course a direct effect of every legislation, but there are also this not direct effects, not like change in culture, change in how companies process personal data, and there are also these effects that are not directly linked to the law enforcement. In Europe, the GDPR has strengthened data protection as a fundamental right and harmonized the interpretation of data protection principles. Rights of individuals have been reinforced, and now our citizens, people in Europe are much more aware of what is happening with their personal data, in particular and online, and what they can do, how to exercise their rights done before. So this is a very huge change that, thanks to the data protection legislation, citizens, individuals living in Europe became much more aware in general about personal data protection, but also about how to protect their rights. Moreover, as you know, in European Union is now 27 member states. European Economic Area is Norway. Adds to this list Norway, Liechtenstein and Iceland. So this 30, I think in total 30 countries benefit now from a single set of rules that brings more legal certainty to business, and also creates a single interlocutor, so a single data protection authority that the particular company is dealing with. This also strengthens the powers of the supervisory authorities. And finally, the GDPR also contributes to increased global visibility of the EU legal framework, and is being, that's what we hear, it's being considered as a model outside of the European Union. I'm not sure how much the Brazilian law is based on the GDPR, but I assume that there had to be some influence. It had to be somehow influenced by the law adopted in Europe. So what we know 2 years after the GDPR is applicable, that although definitely GDPR was a change for good, there are still some challenges we have to deal with. In particular, in Europe, the challenge is a patchwork of national procedures and national practices, which impacts the cooperation mechanism. So between different EU member states, there are differences regarding complaint handling and administrative procedure, admissibility criteria for complaints, duration of proceedings, deadline. And this is something the EDPB is struggling with, and we are in touch with the European Commission and thinking how to improve this. Also, the effective application of power and task attributed to the supervisory authorities in the GDPR depends on the resources available to them. That's why it is essential that then the supervisory authorities in Europe have sufficient financial and technical resources and sufficient staff. This is not always the case. Here you can see some of the documents the European Data Protection Board has issued. On the, at least on my left side, you can see topics that were discussed before the EDPB was established, still before the GDPR became applicable. And there was a number of documents that were prepared, and then after GDPR became applicable, they were adopted by the EDPB. So we have issued guidelines about the consent of individual, profiling, data breaches, transparency, data portability, data protection impact assessment, data protection of users, and for example about fines. And on the right side, of the screen, you can see the guidelines that were adopted already by the EDPB after the GDPR became applicable. For guidelines that might be interested for example, for companies in Brazil, for example, territorial scope might be of interest, because GDPR to a certain extent is applicable also to the controllers and processors outside of the EU. We also, for example, adopted guidelines on certification, on data protection by design and by default, or on targeting of users of social media. Here are, as I mentioned, one of our roles is the advisory role. So here you have some examples of topics, areas where European Data Protection Board provided advice to European Commission. I think one of the most broadly discussed topics is privacy shield. So there was a special document that allowed for transfer of data from EU to United States, and it was recently invalidated. And these are the areas where the board advised the Commission. And I must say that regarding the privacy shield, the board was very critical from the very beginning. Our work plan for this year and for the previous year was basically, as I mentioned, issuing guidelines, participating in the consistency mechanism, and providing advice, but also taking part in international discussions regarding data protection. Now, I would like to focus a little bit on enforcement of the GDPR. We can distinguish two types of cases. So national cases, so cases where the entity that processes the data and the data subject, so individual affected by the processing, are in the same country, and more and more common cross-border cases. Nowadays, in the age of the internet, cross-border cases became very common. And I would like to say a few words about the powers of national supervisory authorities and how the supervision over data protection laws in Europe looks like. As I said, from what I heard about the Brazilian law, I understand that for now there is already a data protection law, but there is no independent agency that supervise the processing, supervise the law and enforce the law. So here, just to give you a glimpse of what are the competences of the EU data protection authorities. But before that, I should also mention the important, like the key element of all European data protection authorities, which is independence. And here we can distinguish institutional independence. So the authority cannot be dependent on government or any other organization. Then functional independence, so authority has to be free to take actions, and material independence, which means that every supervisory authority needs to have sufficient funds, and this is explicitly written in the General Data Protection Law regulation, that each supervisory authority in Europe is provided with human, technical, and financial resources, premises, and infrastructure necessary for the effective performance of its tasks and exercise of its powers. When it comes to I will not go through every power, but just to give you an overview of what are the competences. When it comes to investigative powers, EU supervisory authorities can order controller and processor to provide information. They can carry out investigation. They can obtain access to all personal data and all information that is necessary for their actions, and they can also obtain access to any premises of particular company if it is needed to conduct investigation. When it comes to corrective powers, EU supervisory authorities can issue warning. So before the infringement takes place, they may say, look, to the particular controller, that look, there is a risk that this processing operation may violate EU data protection rules. They may issue reprimands. So this is not a fine, but informing controller or processors that the infringement took place. They may order to comply with data subject's request, bring processing operations into compliance, and for example, online nowadays, we have more and more data breaches. They can order the entity that was subject to data breach to communicate the breach to those that were affected, those people whose data, for example, were stolen in the breach. Then they can impose a ban on processing, order erasure or rectification of data, or what is very important, impose an administrative fine. Fines under GDPR are very high, and this is also a change in comparison to the data protection directive. Finally, the European data protection authorities participate in creating law, but also in advising. They also may advise the companies that process personal data, and also play a role in self-regulations. So in Europe, we are working on codes of conduct and certification in the area of personal data protection. This is also a field where European data protection authorities have a role to play. Now I would like very briefly discuss cooperation in cross-border cases. We have established in Europe something which is called the one-stop shop mechanism, which is a single point of contact for controllers, for entities that and processors that process data in Europe. Just very briefly, the whole mechanism, the whole one-stop shop consists of a number of procedures. So, for example, supervisory authorities can ask each another for help. They can conduct joint operations, and also where it is needed, they may ask European Data Protection Board to issue an opinion or to resolve a dispute that is taking place between the national data protection authorities. In the one-stop shop, there is always one supervisory authority that is responsible for the whole procedure, and it is called the lead supervisory authority, and other supervisory authorities that are involved, they are so-called concerned supervisory authorities. I will not go into detail here, but as you can see on the slide, depending on whether EU supervisory authorities agree or not, the measure can be adopted very quickly. And in case there is no agreement between supervisory authorities, it may reach the European Data Protection Board, and so-called consistency mechanism, where a binding decision will be issued not by those supervisory authorities that are involved directly in the case, but by all the EDPB members, so all EU data protection authorities. What is also interesting, there are many new challenges to data protection. There are many issues that are not clear because, as I said, GDPR is applicable only for 2 years. So that's why the EDPB can also issue opinions on the matters of general application. And in concrete cases, it can issue a binding decision. So to summarize, what I would like to leave you with is that the European Data Protection Board brings together the European national supervisory authorities and the supervisor in charge of the European institutions. The key task of the European Data Protection Board is to ensure the consistent application of the General Data Protection Regulation and to provide guidelines to this end. The EU Data Protection Law, GDPR, is designed to ensure as a single set of rules the data protection rights and liberties of data subjects in the European Union. And this means basically two things. The first thing is a principle of one continent, one law. So basically the laws, the national laws, the data protection law in Europe is currently unified, with some, of course, some exceptions on national level, some sectoral exceptions. And this is where the EDPB plays a role, which is contributing to have one set of privacy rules that are interpreted in a uniform way throughout the continent. And this, for example, is very good for companies doing business in Europe, because it means a significant reduction in their compliance costs if they are active in more than one EU country, and it provides them with a higher legal certainty. An important innovation of the GDPR is the one-stop shop mechanism, something I have mentioned in my slides. This means that a single lead supervisory authority is responsible for drafting a decision in a cross-border case. It also means that the company, that international or multinational company, is have only one interlocutor, deals only with one supervisory authority, which is the lead supervisory authority, and any decision taken by lead supervisory authority is valid across the EU. So my last word is that the philosophy behind the GDPR, to which as the board we are contributing, is to put individuals at the center of privacy practices, building on human rights and values like dignity. One of the main goals of the GDPR is to enable a more functional information economy within the European Union, with more transparency for citizens, which should lead to more companies, to more trust not only towards governments but also towards companies. And from our perspective, the key to a good data protection law lies in establishing an equilibrium between the respect of personal data and the commercial use of data collection and management. To achieve this goal, not only proper legislation, but also supervision and enforcement by an independent agency seems to be necessary. Thank you for your attention. Obrigado.